discuss the nature and the scope of jurisprudence. What is the importance of this subject in the study of law? Nature of jurisprudence. Jurisprudence in its nature is entirely a different subject from other social sciences. The reason for this is that it is not codified but a growing and dynamic subject having no limitation on itself. Its inquiry system is of different status from other subjects. Every jurist does not base his studies on the rules made by but tries to understand their utility after their due deliberation. Thus, jurisprudence has no limited scope, being a growing subject. There is a difference of opinion about the nature of the jurisprudence. It is called both art and science, but to call it science would be more proper and useful. The reason for this is that just as in science we draw conclusions after making systematic study by inventing new methods, in the same way jurisprudence is concerned with the fundamental principles of law and systematic and scientific study of the methods. Scope of jurisprudence. Broadly speaking, jurisprudence is both an intellectual and idealistic abstraction as well as behavioral study of man in society. It includes political, social, economic and cultural ideas. It covers that study of man in relation to study state and society. It covers that study of man in relation to state and society. Jurisprudence involves certain types of investigation into law and investigation of an abstract, general and theoretical nature which seeks to lay the bare essential principles of law and legal systems. Elaborating the point further, Samand observed, in jurisprudence we are not concerned to derive rules from authority and apply them to problem. We are concerned rather to reflect on the nature of legal rules, on the underlying meaning of legal concepts and on the essential features of legal system. This makes the distinction between law and jurisprudence amply clear. Thus, whereas in law whereas in law we look for the rule relevant to the given situation, in jurisprudence we ask what is for a rule to be a legal rule, and what distinguishes law from morality, etiquette and other related phenomena. It therefore follows that jurisprudence comprises philosophy of law, and its object is not to discover new rules but to reflect on the rules already known. Contents of jurisprudence. The contents of jurisprudence are sources. It is true that basic features of a legal system are mainly to be found in its authoritative sources and the nature of working of the legal authority behind those sources. Therefore, it obviously forms the contents of jurisprudence under this head matter, such as custom, legislation, precedent as a source of law, pros and cons of codification of laws, methods of judicial interpretation and reasoning and inquiry into the administration of justice, etc. are included for study.